It's a pleasure for me to be here this afternoon to speak to you about general principles of disability insurance. The idea of this presentation basically is to inform people about the rights that they can avail themselves of in terms of disability insurance. What is the protection offered? What are the main components of that protection? And also, I would like to deal with the incidence of disability on the employment relationship, because very often the insurance protection policies we have are in the workplace, so they're offered when you're employed. Of course, when people are disabled, they're no longer able to provide a work. They can't work as they used to, and the objective of this work contract is to give a benefit if you are a worker, and it may sometimes happen that this objective of giving a work benefit can no longer be met by the disabled person, so that the employment link might be compromised. So in what circumstances might this happen, and what are the elements to be considered? At what time can the employer be justified to put an end to this employment link for a reason of disability? Is something happening with the presentation? No? Okay, great. So without further delay, let me present to you the plan of my presentation. The claim for the disability insurance benefit is the first plan. How do you claim? How do you apply for benefits from the insurer? Secondly, we'll consider the medical reports and exams or tests that can be filed in case you have a recourse or a case. And also, how can you prove disability? What's the evidence required for total disability when you have the chronic fatigue syndrome in particular, which is a pathology where the main symptoms, I would say, are mostly felt by the person subjectively rather than objectified. How can we prove that? Very often the insurer will say, you haven't made objective your symptoms, so that we can't pay the benefit. We can't give you the benefit. What happens in practice in this situation? First of all, I will give you an introduction to allow you to, if you want to understand all these concepts, you should have a general idea of the background or the context. So as an introduction, we'll consider a certain number of insurance guidelines or guiding principles in terms of insurance. First of all, the definition of an insurance contract in the Civil Code is under Article 2389, and there are 3 points in that definition. The insurance contract is the contract by which the insurer, against payment of a premium, is forced to pay to the taker or third a benefit in case of the conditions under the insurance really happen. There's 3 things. The premium, first of all, that's what you have to pay. It's not for free. The insurer doesn't make any favors. When you pay, people have paid for that protection. That's the premium. And then there's the benefit, which is payable by the insurer, but the benefit is payable only when the risk covered by the insurance happens. So everything revolves around the risk assessment. What did the insurance undertake to cover as a risk? And in terms of total disability, that's what's covered usually. When the person responds to total disability, since the premium was paid, then the insurer must generally pay the benefit, unless there are exclusions or any special things. But generally, if the person meets the definition of total disability in a disability insurance contract, the risk happened, and the thing that was covered happened, so then the insurer must pay the benefit. Now, group insurance. Group insurance in the workplace, generally, that's the protection that people have. Group insurance is an insurance where, under a framework agreement, people who are part of a group are covered as part of the group. The notion of this framework agreement, framework contract, is important. That's the only place in the Civil Code where they speak about this contrat cadre, the framework. There's a framework that is in this outline agreement. It's not insured by the insured, but it's insured by a third entity, which is called the taker. To be covered by this call order contract or this master insurance policy, you have to be part of the group. There's a master policy. So the taker can be a taker, an association, an employer. So the taker goes to an insurer and says, I want to insure my staff with a group insurance contract that will include drugs, life, disability, and so on, dental care, and so on. And the insurer says, what is the group for which I want to pay an insurance? And once the contract is made, the outline agreement is made between the taker and the insurer, the group will call them the adherents, the members. as the appeal court says in the Cote case, this is a tripartite contractual arrangement where the real interlocutors, the real people who negotiate the protection, are the taker and the insurer. But it's important to know it's a tripartite agreement because it allows the adherents, the members, even if they did not negotiate, since they're recognized as a third party to the contract, when the risk happens, they don't have to ask permission to the taker to sue the insurer or to claim a benefit from the insurer. They can claim for it directly because they're a party to the contract. We have to make a difference between a self-insured plan. A self-insured plan is an employer who says to his employees, I guarantee the payment of a benefit if you fall sick. The better known example is the public service employees, teachers, nurses, who, under their working conditions, benefit from 2 years of wage insurance, which is paid directly by the employer. There's no insurer involved. It's the employer who pays directly. The employer, that's okay with the government, who has deep pockets and can administer the contract. But some employers are smaller and decide to go that route, and they don't have the expertise required to administer a disability plan for their employees. So what these employers will do often is that they will sign with an insurer an administration contract. The acronyms you see here mean ASO, it's in English, it means Administrative Services Only, and RASNA means Non-Insured Social Benefit Plan. You see that contrary to a group insurance contract, there is no arrow between the insurer and the insured employees. The insurer administers the employer's contract, but ultimately it's the employer who is responsible for paying the benefits to the insured employees. The employees, once they become sick, can claim only from the employer in that case. And the big difference between that and a real insurance contract is in case the employer goes bankrupt. Since the plan is not guaranteed, it's not guaranteed by an insurer. So if the employer goes bankrupt and if the people are covered by a self-insured plan, they're at risk of losing the right to their benefits. That's for sure. We had an illustration of that maybe some 15 years ago when Eaton went bankrupt. And Eaton had a self-insured contract with their employees, and the disabled employees overnight just lost the right to their benefits because the employer was no longer solvent and the contract was not guaranteed by an insurer. So I'd like now to address the issue of how to claim for disability benefits. After this introduction, how can we do that? As I said, generally in a disability insurance contract, the risk that is insured is total disability, and total disability is defined in 2 stages, usually in standard contracts. First stage, usually it's 2 years. Total disability is defined in terms of the capacity to carry out your usual job. We call that the occupational disability. Then, after this period of time, you have a more restricted definition of disability. After 2 years, you'll have another definition of disability, which is non-occupational in nature. In that case, you have to be unable to carry out any other paid employment for which you're reasonably prepared. We'll see some concrete examples in my jurisprudential presentation about how this was really interpreted, because this is really central. So what we have to know is that disability is defined in 2 stages. First of all, whether you're able to do your job, and in the second stage, whether you can do any other possible job. And usually the problems occur when there's a change of definition. Occupational disability, I'll give you a typical definition of what it is in the contracts. They're more or less similar. All these things that are highlighted are almost always there. First of all, occupational disability, what they pay for is a state of disability. That's important. Very often we'll say, we don't pay, and refusal letters, we don't pay, there's no diagnosis. Technically, the definition doesn't say we need a diagnosis. We indemnify a state of disability. Of course, it's easier when there's a diagnosis involved. They ask fewer questions when there's a diagnosis, but technically what they're indemnifying is a state of disability or a state of incapacity which results from a sickness or an accident, an illness or an accident, because it's a disability or illness insurance as opposed to life insurance. And we'll see how the terms sickness and disease are defined later on. the state has to require medical care. That means that the state of incapacity requires medical care. That means that the person who is in a state of disability and is claiming for benefits has to do what their doctor asks them to do to try to get back to a better health as far as possible. And the state of disability must make the insurer totally unable to accomplish the usual tasks of their job. That's the occupational definition because it refers to the inability to carry out your job. Now let's analyze the various elements in this definition. Originally, the state of disability has to originate from a disease or an accident. When these terms are not defined under the policy, well, disease will be interpreted as opposition to an accident. So disease will be considered as being an internal cause, a trouble, a disorder of your health in very broad terms. It will be considered in very broad terms. But the accident is something that comes from an external cause. So if the disability comes from an internal cause, it's a disease. If it comes from an external cause, it's an accident. It doesn't leave a lot of situations that are neither accidents nor diseases. It's either one. The need for medical care, that it's part of the insured to see to his own health. We call that the minimum damage or harm reduction. You have to do whatever is required to come back to work as quickly as possible, as far as possible. But by definition, we won't require for an insured that he should undergo medical care just for the sake of undergoing medical care if the doctors cannot offer them anything more. Best example of that is an old decision of 1928, which doesn't make us feel any younger, the Barbeau against Merchant Casualty, where Mr. Barbeau had cataracts. And his insurance policy said that he had to produce a doctor note every 7 days, otherwise he would lose the right to benefits. So he was always with the doctor, and the doctor at one point said, look, you have cataracts. I'll be able to operate on them in 6 months. They're not ready for an operation, so stop seeing me. So Mr. Barbeau stopped producing doctor's notes. He was cut by his insurer. He contested the insurer's decision, saying that this care was useless and he was just bothering his doctor for nothing. And the appeal court said, you're right, it's an unreasonable interpretation you're making. Yes, he needs to take medical care, but this medical care has got to be useful. Just going to the doctor for the sake of getting a note is not really useful. Then the third element in the definition is that the state of disability must make the person totally incapable of doing their usual job. Totally unable. The Supreme Court of Canada interpreted this as meaning substantially unable, which is a big difference. In the Paul Revere Life Insurance versus Carroll, there's an E missing in Revere, Paul Revere versus Sukharov. It's a typo here. In Paul Revere Insurance against Sakharov, Mr. Revere was an entrepreneur with his own shop, his own company. Mr. Sukharov had health problems with his heart. And the problem, when he had to meet clients to develop the business, he had panic attacks. He had angina when he had to meet a new client. He was no longer able to do that part of his usual job, which was about 50% of his work time. So the insurer said, Mr. Sukharov, we don't pay because you're not totally unable to carry out your job. It went all the way to the Supreme Court. And the Supreme Court said, listen, the idea behind disability insurance is to allow the person to continue to receive some income when they're no longer able to get enough comparable income through their work. Here, Mr. Sukharov, clearly, if he continues to operate his business, he's going directly to bankruptcy. Substantially, this gentleman is no longer able to carry out his usual job. And that's when the Supreme Court says we have to interpret the term totally unable based on the purpose of that contract, based on what was envisaged by the parties. The Sukharov case dates back to 1983, but you see that in subsequent decision, the Quebec Court of Appeal reiterated the concept of totally unable means only substantially unable because of the expectations of the parties to the contract. the insurance contract. So what we have to remember, the test to determine whether a person is totally unable, the test which I consider as being decisive after reading all the jurisprudence, is given the state of the person currently, would an employer be satisfied with the type of work that this person is able to carry out, or will that end up with a layoff or a firing because of insufficient performance? If a person calls every 2 weeks to say, I won't come in today because I don't feel well enough, that will end finally with a firing. This is more like a dismissal. This is a substantial disability rather than the opposite. I have to point this way. That was for occupational disability, inability to carry out your own job. Now, after a period of usually 2 years, you have a change of definition. The notion of disability becomes more restrictive, and here the person has to be unable not only to carry out their usual job, but to carry out any other paying job if they want to continue to benefit from the insurance protection. The typical definition of non-occupational disability repeats the elements we just saw. It's a state of disability which comes from a disease or an accident, internal or external cause, which requires medical care, and which this time makes the insured totally unable, so substantially unable, to carry out any paying job for which the person is reasonably prepared because of his education, training, and experience.
That another job where you can earn an income. This refers to the idea of the income. We have to take into account the previous income, the person's previous. We want to see what a kind of a job would generate this kind of an income. The person should be able to arrive at the same level of income. So a person who was making $50,000 before becoming ill, they were paying a premium for a $50,000 salary. This person is therefore more insured than the person making $25,000 and who was paying a premium for that amount. The job pays more for somebody who's doing 50,000, and that the appropriate job has to be closer to $50,000, and the person making less would have to accept something that generates less income. So in disability insurance, there's a percentage that is paid. The more they were earning, the more they were going to be paid. So the person has to be reasonably prepared to do the work that is to generate the income that it requires. If a person has worked, was a manual worker all of his life, and overnight they're being asked to do computer work, if we did not provide this person a training component to upgrade them to a level to be able to transition to another kind of job. So there's another element here that requires interpretation. So in disability insurance, it's all or nothing. If the risk actually occurred, if the person is disabled, the total, the insurance, if he is totally disabled, he has to be paid completely. But if he isn't, then the insurance is not required to pay him. So if it's all or nothing, we cannot to interpret the clause not to pay the insured party the required amount. The person at the end of the process would end up earning practically nothing. The insurance will not cover partial disability. So the insurance company might decide to cut the person because the employer says this person could work 1 or 2 days. because that insurer may not be right, because the Court of Appeal says if the person was earning $25,000 a year, but if they're working less, then they're earning less, and this stipulation cannot mean that it's totally invalid. It's not all, because it says all or nothing. The other equivalent job has to provide a lifestyle that is similar to the one that they're used to. So there's insurance policies that specify in the contract that the next job with the appropriate revenue will be the same. 67%, they will set an amount to, at 50%, I'm not convinced that it's a legal clause, actually, because there's no jurisprudence on this, but there are cases in Ontario that were reported in this regard. In Quebec, the jurisprudence says that the new job identified by the insurer has to have an affinity with the income that the person was making earlier. So we have to take into account the total picture. Most of the files, people find it difficult to prepare in the morning. Once I prepared myself to work, I have no more energy left. So you have to consider that the person has to get up, perform the morning hygiene routines, go to work, and perform the work, and then come home and then repeat this thing. It has to be able to happen 5 days a week. Can the person maintain this kind of a cadence? So when we have to consider that, because if the person breaks down in the process, that's not very good. So if you have 5 hours that you can work in a day, you're able to work. But if you can take 2 or 3 hours to go to work, then I end up with only a very short time to actually perform the work itself. Also, and in the analysis related to a non-occupational disability, we have to take into account the person's personal qualities. What is transferable that this person has in terms of competencies and so on? The insurer will ask for psychometric tests and so on to try and see what they're qualified to do, to identify a compatible job with that profile of the insured person. Assurance Desjardins versus Roby, and he was a butcher all of his life, and he was no longer able to do this, and the insurer wanted to put him into another area altogether. The court said, Mr. Roby, you can't ask him to do this kind of thing at an age where he's much closer to retirement time. There's less time left to work than he has worked previously. So in a younger person, you'll have greater expectations for, but someone who is older may not be that easy to recycle. So if we look at the principles of interpretation, so when disability insurance is purchased, we're buying security. Fiddler versus Sun Life, it's a peace of mind contract. That's what that was bought. So by paying the premium, we have that peace of mind. We're safe. The insurance will pay. And you look at the publicity, there are never problems. And the person is in the hammock, and the pina colada is right there, and the money comes in automatically to the bank. If that's what you're selling when the event occurs, that must be the result. So it's a contract of the highest good faith, because the insurance company doesn't know anything about the person's medical condition. In collective insurance, that's even truer because we have no direct proof. All we know is that you're working, and so we now have a collective insurance plan that you can qualify for. You have no medical examination, and you're insured. So when you become sick, the insurer can ask you certain things. I'm sick now, I can't work anymore, but the insurer can ask for proof of that. So you're required to be in good faith, but the insurer must also be in good faith, and so you can expect that. And finally, there's a finality of that contract. You're buying safety, you're buying a level of standard of living that is comparable to the one in the past, and we're expecting the insurance to enable you to do that. We want to pay a premium, but never claim anyone. I've never seen anyone, very many people, get rich doing that. It's not people's career plans at all. Other special effect. So if the claims process, so we're now dealing with a person, an insured person, and the person is no longer able to work, and there's a claim that's put in. The insured has to inform the insurer of what happened, of what disability took place. He's going to be asked to fill out a form, a 3-part form. The part that we need to fill out, the employer fills out, and the treating physician. So for 90 days, all of this has to be submitted. So, and those are all the information related to the circumstances and the extent of the claim. So it's not dramatic if it doesn't happen, but if we're not in if we are no longer able to work, but the money has to be sent, if you wait longer than 1 year to inform the insurer that you are ill, you may be told that it's too late. I saw a case in jurisprudence. The person was suffering of fibromyalgia, and it took me 1.5 years or 3 years to get my diagnosis, and you had to submit your claim when it happened. It's a state of disability that you need to talk about. If the person stops working due to a state of disability, you have to advise the insurer, even though the process isn't completed on the other around the person. So the claims process, so if the insurer received the claim and refuses to pay it, the insured has 3 years to file suit against the insurer. And there's a new prescription that starts every month. So it's something that is payable every month. So there's a new prescription every month. So if the person claims based on the work process and arbitration, I invite you to consult your union or so this usually can't take longer than 6 months. So the burden of the proof, who has to demonstrate the disability, is the insured person has to demonstrate that. According to Article 2803, somebody who is claiming for something has to demonstrate it. If the insurer pays for this situation, they de facto agree with the claim. So the disability is accepted, and from that point, the burden of proof changes sides. So the person submits the claim, the insurance company pays. The insurance company, therefore, recognizes that this claim is justified. But if then later on the payments are cut, then the insurer has to demonstrate that there's a reason for that. So when the definition changes, so if we're saying your own work and then any other comparable work, then the insurer has to demonstrate that the second definition corresponds to the requirements. So if the insurer admits that the worker actually corresponds to this profile before the insurer can actually agree that the other person can't do the work, the insurer will naturally verify a little more specifically what is going on. So in a context where the parties are not in court over this, the insured has submitted a claim, and the insurance company is entitled to look at a medical evaluation. So it's normal that in a management process that the insurer checks on what the insured is claiming. So it's Article 2438 of the Civil Code. There's, in fact, a clause there that mentions that a medical examination is required on the part of the insured person. So when the insurer, if that is not done, then the insurer can say, well, I'll suspend all of my payments until I receive this information. And that's usually a very convincing argument, and people will go for a medical examination. So in the context when there is legal haggling over this between the insured and the insurer, what we want to get the medical exams, and it's not the policy that is going to manage this. It's going to become the civil code, because people are in court by then, and so that's quite different. So first of all, the person who is in a legal case claims that or indicates that his state of health is at a certain level, the insurance company will ask for the medical claims, and there's very little that can be done. That the primary criterion here, and we have Gregg against Smith and Nephew. These were evaluatory notes from a psychologist, and the psychologist was refusing that these notes be presented in court, and it went all the way up to the Supreme Court, and the Supreme Court said no. If it's relevant for the analysis of the question submitted to the judge, then those things have to become presented as evidence, but they can be, of course, presented. Not just anybody can have access to this. They have to be sealed, and if you have a claims injustice, the insurer can receive all the relevant information regarding the insured party in terms of the medical file. So, if we look at the medical examinations, the insurer can ask for one based on Article 399 of the Civil Code, and in all cases where the physical and mental state of a person is required, the insurer will request a medical expertise. The insurer can also request an additional expertise, but it's not automatic. the insured party can refuse to do that, and the court then will decide according to the discretionary powers that they're entitled in 399.9. In the fall of 2015, there are big changes coming. So especially in the regarding the criterion of proportionality. And so requesting expert evidence takes longer and is heavy and expensive. And if we have people claiming opposite positions, there's a trend now to limit the request for expertise and to encourage dialogue between the parties. And the judge says, is this really necessary to have 2, 3, or 4 experts? Does that so this limits the discretion of the courts, and the judge must remain accessible. It limits the recourse to the expertises that we could see earlier. The civil code, changes to the civil code, will restrict that even further. So another important element in context where litigation takes place, the additional examinations can be complementary, and then it'll be required. The first expert will examine the person. In my field of specialization, there's all of this, but we would need more psychiatric, let's say, evaluations here, because the first expert says that this goes beyond my expertise. So frequently in that instance, the courts will accept a second expertise. But if we do have an expertise already, and the judge may very well say, why do we need another one? We don't want to accumulate expertises. We want what is required. And in the additional examinations, in the cases of chronic fatigue, where symptoms can be objectivized, we can request neuropsychological expertise. We can have standardized tests given to the person, and we can simulate the capacity to do work over several days, and those things may be authorized in a judicial context. If a person, an examined person, requires it, they may be accompanied by an expert of choice. The lawyer may not be there. Even if the person's lawyer would be there, may not be critical on the work done by the expert, but an expert in that same field of specialization, as he or she watches the expert working, they can comment on the expert's report and the way the process takes place. So there's a very important decision that came out in 2013 in Industrielle Alliance Insurance against Madame Lebel. So this woman we needed to measure her resistance to fatigue. She went there with her own expert, and the tests that she was submitted to were evaluated, and he also produced a report. And the Court of Appeal said that the person accompanying the person, they may be a witness to the test that actually took place, and they may point out the strengths and weaknesses of the methodology that was used and have a critical view on it, analyze the medical report of that expert, add additional information, and come up with his own suggestions. So, and have a critical view of the capacity of a person to do a work or not, based on the exam that they attended. So a person who is suffering, let's say, from a pathology that generates a lot of fatigue and pain, and that undergoes an evaluation of functional capacities, the evaluator is not inside her. And if the person says, I'm too tired, I need to rest, this is too painful, the person can believe you, or he can claim that you refuse to collaborate. So if there's no other accompanying expert, then it'll be the word of the person against the word of the expert. If there's somebody, an expert, accompanying the person, then things can be quite different. So the level of proof, I know that's a lot of things. This is a condensed version of the situation. So the level of proof, do we need to prove scientifically that we are suffering from chronic fatigue? In law, this is not the way it's done. We are lawyers and judges. So it's the legal causality, preponderance of likelihood. So what we need to demonstrate in law is what we are saying is more likely than what the other party is arguing. So the court cannot insist in unlike criminal law, so it's not beyond all possible doubts. A woman is hit by someone and has a back pain as a result of this accident. The claim is made to the SAAK, and then all of a sudden she ends up with fibromyalgic pains, and this person insists on having this recognized as a result of the car accident, and this person brings in an expert that argues this point. He's asked, are you ready to relate the fibromyalgia to the car accident? I can't say that it's a result of the car accident, but what I can tell you, but I can't see another cause than the car accident to explain this fibromyalgia. So Madame Vigier lost the case, and she went to the Court of Appeal, and the criterion of proof that we insisted on from Madame Vigier, she needed to produce evidence, scientific evidence, whereas all she needed to do, and she had to do, was she won that case at the Court of Appeal because all she needed to do was to argue that the most likely cause was this one, and there is no other likely cause, and the other party has to say, no, there is another cause, and then name it. Otherwise, then Madame Vigier was correct in her presentation. So it's our criteria in civil law. So when you have experts, you have to remind them of this particular reality. Yes, because frequently it'll end with a question of credibility. There's experts on one hand, they'll say this person can work, and on the other, this person cannot work. And the person making the claim, is this person credible? Are the symptoms believed by the court? Are there people that can support her position on this? Are there people who knew her before and now? And this kind of proof can, by preponderance of evidence, based on all of the information, factual information that is presented, is more likely than the theory that the expert is saying, because the expert says, I think this person would be able to work because I haven't found any reason for her not to. So there's a preponderance of likelihood that this is true. There are two kinds of witnesses. Witnesses of facts these are the ordinary witnesses, people who have seen things, people close to the claimant, friends, colleagues. Those are people that are not experts. But then you have expert witnesses. They don't mention things that they know for a fact, but they will say, I've looked at all this. Given the knowledge that I have, I argue that. So the expert evidence presents points that don't depend on the court's expertise as such. An expertise is a house on wooden pillars. The expert will formulate a conclusion, but that has to be based on facts. If the expert says, the proof that I have that the person is able to take care of her daily chores, that the person can go outside and so on, but if the person demonstrates that this person does different things based on witnesses, then the expert opinion becomes questionable. So if we look at Lorraine, the Queen versus Abbey, so everything is hearsay. You have to be very, very careful. So the elements that the expert uses to convince himself and the witnesses of fact, so everything has to be demonstrated. There's no hierarchy between an expert and a regular witness. So the judge can decide, this is the person that I believe, and this has to do with the power of the court. Yet there are decisions that concluded that when the opinions of the experts were quite different, and they were significantly different, then the court can say, can accept the testimony of the other witnesses. So I'll end quickly on the consequences, on the disability, on the work relationship. So the contract requires that a work be performed, that after a certain time you may end up with a deception of contract. The work contract may no longer be met by the person who is not able to work. That could have an impact on the work contract. So somebody who has been present for 3 months can actually leave. They may not be fired because they were ill less than 26 weeks within a year. This is the law that protects them of less than 26 weeks over a 1-year period. The work contract may protect them even more than what is provided for. The nurses who become ill will not be fired before they have been absent for 3 years, which is longer than what?
Because the Standards Act is really a floor. If the employee is dismissed because he's still unable to work after the end of the period provided under the work contract, now we do an analysis in terms of accommodation. Could the person be accommodated by returning to work in a different position? But there should be a real capacity to return and a reasonable prognosis and a timetable for returning to work. When the fundamental obligation linked with the employment relationship can no longer be fulfilled in the predictable future, then the obligation to accommodate will be judged excessive for the employer. In the Hydro-Quebec ruling, This was someone who was had been accommodated by his employer for several years. He was no longer able to do a full task. He was only working 3 days a week, if I'm not mistaken. And the Supreme Court says that the obligation to accommodate doesn't go as far as modifying the position or creating a new position based on the person's abilities. So the person who is no longer able to meet the fundamental requirements of his or her job cannot claim through an accommodation and a modification of his type of work. So if the person loses their job because he or she is unable to come back to work, but if the person is disabled, then the insurer will be forced to continue to pay the benefit, even despite the fact that the work contract is not taking place, because the disability occurs only once at the beginning, and it continues month by month. But it's the initial disability that the insurer is paying for and its continuance. So the person has an acquired right to the benefit as long as she becomes disabled under the contract. And second of all, if the insurer with a disabled employee wants the employee to get into a rehabilitation program adapted to his condition, he can do that. The person must minimize their damages and, under the care of a doctor, do whatever they have to do to recover their health. But the doctor has to agree with that. The treating physician has to agree with the rehabilitation program, because if the program is not well adapted to the person, it might do more harm than good. It might aggravate the condition of the person. Then the physician will not necessarily agree with that rehabilitation program, and the person will be under the physician's care, and the person has to do what the doctor tells us. Damned if you do it, damned if you don't situation. What should they do? The employer's will or the doctor's will? In jurisprudence, we say if the insured doesn't have the agreement of the treating physician, then it cannot be required of the insured to initiate a rehabilitation program if they don't get the treating physician's consent. So that completes my presentation. I'll conclude with this pun by Edmond Deschamps. It's better to be rich and healthy than poor and sick. It's not even a pun, it's just the truth. If you have